Okay, we're ready.
Okay, well, thank you everybody for being here. My name is Miguel. I'm the Director of Public Services for the San Fernando Valley Bar Association. Today we have Ms. Ani Akbarian with us to go over some basics related to family law. Again, so if you have any questions, just put them in the chat and then we'll get to as many of them as possible after the presentation. Otherwise, with anything else, you can always reach out to the referral service and then give us a call and we can still get you a free consultation with an attorney. Um, Ani Akbarian is a family law attorney. She's been practicing for quite a while. She's an amazing attorney. With that, I'll turn it over to Ani.
Thank you, Miguel. Thanks, Linda. Thank you both for um, inviting me to this interesting and nice event. I appreciate you guys for considering me. Um, I believe we have a couple of things that we want to talk about family law, which is divorce and custody, and you know, uh, generally divorce is where people would formally end their marriage and they would address the division of their assets, the child custody and child support obligations. This is that process. And while it's emotionally challenging, I believe that understanding the process can help the individuals navigate this significant life transition more efficiently or more effectively. There are different ways to approach divorce. There's uncontested ways where parties can agree on major issues and um, have a mutual understanding of what will be, and if they're okay with it, they're going to agree to those terms. Usually, it's faster, it's less expensive, and it's probably the optimal, option. Uh, the other form would be the contested divorces, where there are disagreements on one or more major issues requiring court intervention, requiring hiring of attorney services, services of an attorney. It can be expensive, and it can take a longer time. Generally, it can be anywhere from minimum 6 months to maybe 2, 3 years, and sometimes longer, I have seen. So it all depends on the nature of the contention. And then, of course, we have the mediation process where both parties mediate their differences through a neutral third party who doesn't have any interest or represents neither party in the action, but does give them advice as to, given the circumstances of each party, what would be the best course of action, and help them to get to some sort of an agreement. And this is probably one of the next best thing to an uncontested divorce, because then you have control over the outcome of the decisions that you make, and it's not a judge who would make that decision for you. It's less adversarial, it's less expensive, and perhaps it can be done in a much uh, faster fashion, less time. Now, as to what it takes to start the divorce, there's a myth among people saying that, whoever files first, it's better. There's no difference as to who files. You can file the petition or the other party can file the petition. It makes no difference. It does not give you any advantages or disadvantages. Once you file the petition, in that petition, you will be requesting and addressing issues such as uh, custody, if there are children involved, support for children, and support for spouses, for the spouse, attorney's fees, um, is if there are any restraining orders that have previously been addressed and ordered. All of those are going to go in your petition. It's important that the petition is filed properly and with an intention. And when I say with an intention, I mean that you want to make sure that that petition is completely done the way it needs to be done, because down the road, if things change, you can't go back and ask for something that you haven't asked in the petition, that you may not be able to get what you're asking for at the time of trial. So it's important to have that done properly. More than I can remember, many, many times it has happened where parties have had their petitions prepared at a legal service. It has been incomplete, inaccurate. We had to go back and redo the whole thing again. But that would require us to go and file a motion with the court, get a permission from the court, and then refile the way it needs to be filed. So it's important to have that petition done correctly. Once that petition is filed with the court, the other party will have 30 days to respond to those, to the petition. And from there on, once the petition is, the response is filed, then both parties have an obligation to do disclosure. What disclosure means is that any financial assets, liabilities, anything that they have accumulated during marriage, it's subject to disclosure. There's a law that requires each party to disclose fully all financial assets and liabilities. And the reason for that is because if parties are going to reach an agreement or a judge is going to make an order at the end, it's based on what the parties have disclosed. If for some reason one of the parties failed to disclose their assets in their disclosure papers, then the other party, upon finding out about the existence of that particular asset, can go back to court. And a lot of times the court would not just divide that asset that's been newly discovered in 50-50, as the community property laws will require in California. The spouse may lose 100% of the asset to the other party. So it's important that we have those disclosures done properly and accurately. After that, then there's the discovery phase, where you both will request discoveries from one another, further financial documentations to support whatever claim that each one of you may have. And I think that would be a pivotal step in any kind of divorce proceeding. It's very important, because at the end of the day, the discovery, the evidence that are being produced are the evidence that are going to be presented at trial, and that will make or break your case. So that's very important to make sure that discoveries are done, that all the disclosures have been made before you head towards trial. Of course, the idea is always, and I always tell to my clients, the best way to address a divorce is to do it when you guys agree, when you guys start talking to each other, communicate with one another, and try to come to some sort of an agreement with one another. That would be the best way to handle it. But unfortunately, it takes two people to be able to come to an agreement. And if one of the parties is not being reasonable, or for some reason or another can't come to an agreement with the other spouse, then I guess, we go to court and we let the judge decide. But I always encourage everyone to try to communicate one another if possible and when possible, because the outcomes can be much better. It could take you less time and far more financially efficient. When it comes to custody, I think one of the most important things in the divorce proceedings is custody. And that's what I want to talk about, really. Why custody? Because a lot of people have children and they get divorced, and there's a lot of unknown involved in how is it going to happen, what's going to happen, and who is going to have the children. Now, under the California law, which is basically the premise on which our family courts are functioning, the best interest of the children is always the most important factor that the courts are considering. So, in order to determine custody, the court will look at two different factors. One would be the physical custody. The other one would be the legal custody. When we talk about legal custody, we're talking about the rights of the children. That could be about getting passports, education, medical needs. Those would be considered as legal custody. When we're talking about physical custody, then we're talking about children, living with one parent or both parent or the other. So it would be their physical presence. Where would they be living as they're growing up? With physical custody, one parent may seek for primary custody, which would be having the child at least 80% of the time, and the other spouse having visitation rights with the child. And again, could be 20%, could be more, but that's generally where it starts. It could be joint physical custody, where both parents actually care and have physical custody of the child, whether it's on a weekly basis, whether they're switching week in, week off, week on, or days, certain days during the week, the exchanges take place. And then, of course, there's times where a parent may have sole physical custody of the child, and that is because and it's almost interchangeably used between primary and a sole physical custody, but there could be times where the other parent has limitation in visitation, and the court basically addresses and orders sole physical custody to one child. When it comes to legal custody, again, the legal custody could be separated again the same way, either 50-50, or it gets divided in percentage between the parents. Normally, generally, the common practice is that the court will order 50-50 legal custody to the children, unless one of the parents either is engaged in prostitution, drug, having major criminal background, involving criminal activities, anything that would harm the best interest of the child would be what the court is going to consider in determining whether that parent would be entitled to a legal custody. And then, of course, once that is determined, again, it's pretty complex when it comes to custody, only because there are times that the children would have a preference for being in custody of one child, a parent versus the other, and that depends on their age. So after the age of 12 or 13, I would say about 13, 14, the court listens to the children's preferences when it comes to custody. However, prior to that, that doesn't happen. A lot of times, if a need for evaluation is, necessary, then, there are parental evaluation that's done through the court. We call it PPA, or outside evaluators will be evaluating But generally, no matter how we deal with this, the courts are looking at the best interest of the child. What would be the best interest of a child when they decide who is going to have custody? And then one of the other things would be that if they're in certain cases when the children are a little bit older, let's say they're in 7 or 8 years old, if they need to have an attorney they can have an attorney representing them in the custody matter if necessary. Usually this is something that the court will have to appoint, and it's a motion that has to be made to the court by either party if the circumstances lend to it. We do have then the other aspect of it would be support. Children support is one of the important factors that the court will determine. It must be determined. And so the way they do this is by looking at the income of the parties, the amount of time that the parties are spending with the children, that all of that is going to go into a particular software, and the court basically puts all the relevant information that needs to be put in there, and that is a whole subject of its own. And then that's how the court comes up with a child support calculation. Usually it's called guideline support for the children. For temporary support of spousal, we do the same thing as well. Again, temporary orders are orders that are made during the time, from the time that the petition is filed until the trial. Any orders that are made are considered as temporary orders. And then once the case is either tried or judgment is entered, whether by parties stipulation or by order of the court, then those orders become permanent. So that's kind of giving you a very general idea of what to expect if you are to file for divorce and you have children. Aside from that, then of course you have your community asset that you have to deal with. Again, that's a whole different subject that needs to be dealt with to determine what is community, what is separate property. And it's going back to what I was saying about the petition being accurate. One of the most important aspects of that petition to be accurate is the separation date, because the separation date dictates the date from the point where all the financial information kind of comes to a halt. In other words, all the income, all the assets and everything, it kind of stops at that point. So anything between the date of marriage until the date of separation is something that the court's going to look at for the purposes of division. But then as far as the support, it continues. The court will look into further financial records after the date of separation until either the parties are trying the case or they're requesting orders to determine support based on whatever ongoing financial records that are available from both parties. The types of assets that the court is going to consider would be real estate, retirement, bank account, businesses, personal properties, debts and liabilities, and that's pretty much it. Now, going back to the process for divorce, because we are under the California community property laws, usually assets that have been obtained during marriage are presumed to be community property, and they are subject to equal division unless otherwise. And when I say otherwise, there are a whole bunch of other exceptions, but I don't think that would be a subject of today because it would be very confusing if I go into details on those. So, and also, for the purposes of the petition, once the petition is being filed, we will have to make sure that whoever files a petition is at least has at least 3 months residency in the county of Los Angeles and 6 months in the state of California. That is the minimum requirement before you can file the petition for dissolution of marriage. Pretty much, this is very brief. It's it kind of gives you an overview from of what a divorce proceeding involves. And every aspect of what I just said has a whole lot of other avenues and branches that we can explore. But I don't think we have time today to be able to go through that, unfortunately. So with that said, I don't know if there are any questions. I'll be happy to answer. Let's see here. We have
All right. So yeah, so if any I thank you so much. So we'll leave it here on